A critical decision today, coming from Judge Duane St, even before opening statements this morning, is if Donald Trump testifies, prosecutors can then ask him about different findings in 4 previous court cases, including the E. Jean Carroll defamation verdicts and his agreement to dissolve the Trump Foundation. Joining us now is Jeremy Saland, criminal defense attorney and former assistant DA in the trial division of the Manhattan DA's office. Thank you so much.
My pleasure.
It's good to see you. So talk about what Judge St did. He kind of divided. He said that the sexual finding of, in the sex case cannot be held again, cannot be introduced rather, but that he can be asked about the defamation. So he separated it between the financial issues, and these were all civil cases, not criminal cases, and it's a different burden of proof. It doesn't have to be beyond a reasonable doubt.
That's absolutely true. And there's a balance here. There's a prejudicial value, and then there's the other value of bias as well. And you want to understand, how does this impact his credibility? In a very limited circumstance, this ruling says, these prior immoral, criminal, even use the term vicious bad acts, as the law says.
Well, they're not criminal, they were civil.
Well, these were, but I'm talking about the law that allows for, correct. So it allows for certain types of cases and certain types of past history to be admitted solely for the purpose of credibility. So an allegation and even a confirmation in a civil proceeding of some sort of sex abuse, that you're right, that is a lower standard. But when you have issues of credibility about being told not to say something, for example, about the court's clerk, but you post something and you don't take it down, that would be a finding. If you're Trump.org, if there's issues with cooking the books or tax issues, that would be something that goes to his credibility. So it goes directly to veracity and truthfulness, but there's a balance because it can't be too biased and hurt him.
And we were talking just before you came on about the fact that his lawyers shouldn't be letting him talk about anything in front of the jury, not in front of the jury, coming out of the court, because anything that he says can then be used to challenge his veracity, his truthfulness.
Absolutely.
Or the veracity of their case if he's not testifying.
And not just that, not just his truthfulness. If he says something inconsistent that he said previously, or that's something that's in the evidence, in the case in chief, meaning the prosecution's actual case, they could potentially lay that foundation and when and if he testifies, cross him on that. So it's foolish, it's naive. When we talk about the big picture here, Donald Trump is playing to politics outside for the presidency. But if he damns himself in the courtroom or outside the courtroom by saying things that can be used against him by the prosecution, he's going to find himself boxed in.
Well, let me just give you an example from today. He came out and he said, this was just bookkeeping. Just bookkeeping. I was just paying my lawyers. I'm being indicted for just bookkeeping. Never before in the history of America has this happened to anyone.
Simply untrue. Maybe the former president of the United States, but I was a prosecutor, but I'm a defense attorney now. If that defense worked, it was just bookkeeping, I would use it every time, twice on Tuesdays. So it's really, really a ridiculous claim. It's a ridiculous claim.
When does something like that cross over, though, from go from being untrue? And I think that is baked in, right, for a lot of these jurors. They know what the accusations have been against Donald Trump. They know some of the things that he said, unless, for example, they're election deniers and believe that Joe Biden is not the legitimate president of the United States. That kind of stuff is baked in. Where could he possibly get into trouble with what kinds of statements, though?
Well, there's different kinds of trouble. One might be in trouble for violating the gag order, where if he starts going after Michael Cohen or another witness beyond the scope, really that was allowable, and attacking them personally, going after the judge. There's the gag order, very limited capacity about what he can or can't say as it involves these witnesses and people like the judge and prosecutor. So there's that issue, which could potentially be a fine and contempt and theoretically incarceration, though not likely. Then on the flip of that, there's what we said before about his credibility and what he says potentially on the stand. If he testifies, though, I think he's boasting a lot. I wonder if, in fact, he really will. So there's 2 types of dangers for him. Always the prosecution's burden to prove beyond a reasonable doubt, but he's kind of giving them a little bit of a lob when he speaks and runs his mouth. And his attorney should be grabbing him by that collar and pulling him back.
Maybe they can't.
Maybe they can. And certainly I've had clients, and I've seen as a prosecutor, defendants doing this, and I get it. He's the former president. But he maybe can't see the forest from the trees. And one of your roles or jobs as an attorney is not just to protect him in that courtroom, but silence him and protect him outside that courtroom. Because if he says the wrong things, he's not going to become the president of the United States in the future.
So interesting. Jeremy, thank you so much for coming in. We really appreciate it.